This leads me to. Now,
Right.
All right, good morning, everyone. This is the Court of Appeals sitting in Bermuda, calling Civil Appeal number 9 of 2020, the matter of Andrew Crisson against Marshall Diel and Meyer, a renewed application after a refusal for an extension of time by a single justice. All right, good morning, everyone. This is the Court of Appeals sitting in Bermuda, calling Civil Appeal number 9 of 2020, the matter of Andrew.
Sorry, what is going on? Queller, you seem to have spoken first and then your voice reappeared.
Yes, we've got.
We all in order?
We're in order.
Okay,
Well,
it's good to hear from you, but not twice. Right. Yes, Mr. Hill.
I will just commence. This is a renewed application. The basis of the application, I will place it in the context of how things have unfolded, if I might. I hope that your lordships and your ladyship have my brief submissions. This is a case which commenced by writ on the 13th of December 2019. I'm not entirely sure whether the documents have got, the evidence, as it were, or the documents have got before your lordships and your ladyship, and that.
Well,
that
some of them have and some of them haven't.
But if I begin my narrative and my narrative causes a problem because one of the documents is not there, or someone thinks I'm saying something which is incorrect, then I'm sure you'll let me know. The case began, as I say, on December the 13th, 2019, by the obtaining of an injunction, which appears to be an injunction in the form of a Morava injunction. The order was obtained on the basis of an affidavit, the first affidavit of Georgia Marshall. That affidavit was sworn in support of the facts contained in a writ, especially endorsed writ of summons, which is purported to set out a case against Mr. Crisson in what I would call debt. It is not a case advanced on the basis of the retainer.
But just to, I mean, we do not have the first affidavit of Mrs. Marshall. It's referred to, and passages are quoted from it in the Chief Justice's judgment. We have, I suppose, in a sense, the writ and statement of claim, in that we have the amendments to the writ and the statement of claim.
Yes. I have to say that the amendments are rather peculiar in that they weren't before the judge, in the sense that no application had been made for the amendments, and the copy of the amendments had not been sent to me because there was this problem with the alleged bulkaya.
Yes.
So I was not provided with a copy of that at any point in the proceedings.
You've got one now.
I've got it now, yes, because this lordship found that there were no bulkaya issues in relation to me. The transcript of what took place before Stoneham PJ appears in the exhibit to the first affidavit of Cameron Angus Hill, which I believe your lordships and ladyship do have.
We do.
And the grounds of appeal, as they're structured, make, and I'll paraphrase rather than go through them because I believe we only have an hour, make the complaint. And the complaint, it works in this way. It must be extremely rare, and certainly I've never seen it, where an application to vary an injunction, which I still call it a Morava injunction, an application to vary that injunction takes place before the application to set aside that injunction. And so the Chief Justice was confronted on that day, and only to a limited extent, with the first application inter partes, which dealt with the substance, effect, and scope, and characterization, in fact, of the injunction granted. And in his lordship's ruling, he has rather avoided the thorny problem of whether or not there's a cause of action and whether or not there is an actual pleading that sets out the basis for a proprietary claim. He simply examines the words used by the party, Mrs. Marshall in particular, to try and say whether she meant to make a proprietary, or it could be construed, and that's the word he used. It's arguable that this document can be construed to be an application for a proprietary injunction, whereas in actual fact, the word proprietary, lien, solicitor, and so on do not appear in the transcript of the hearing. They do not appear in the initial writ. They do not appear in the affidavit of Mrs. Marshall, and the application was not made on the basis of any proprietary interest that arises as a result of the solicitor's lien. And the answer to that is simple. It's because the application was not made on the basis of a solicitor's retainer, which would give rise to a lien. It was made on the basis of an acknowledgement of debt, which terminated settled, as it were, the claims based on the retainer, and created a whole new set of obligations in debt, which had the effect of extinguishing all of the rights and obligations of the parties. That would be the obligations of Mrs. Marshall to claim a lien under the solicitor's retainer, for example. But it would also extinguish...
Wait a minute. If I agree with my solicitor that the amount that I owe him is $250,000, and I agree that I will pay it in various different ways, or other people will pay it for me, that can't deprive him of a lien for his costs just because I've agreed what they are, can it?
Yes, that's exactly what it does. That's the general law. The general law is that if you compromise a claim, and there was a compromise, there was a reduction in the number, and there was an extinguishment of rights because it extinguished my client's right, for example, to counterclaim. It extinguished my client's right to the usual reviews that are available, say, through the taxing master in England of a bill that's presented by a solicitor in relation to litigation. It extinguished his right to have it reviewed by the Bar Council under the rules of the Bermuda Bar. And so it had the effect of extinguishing all of the rights and obligations under the retainer and replacing those rights and obligations with the rights and obligations which are contained in the acknowledgement of debt. And the acknowledgement of debt is nothing other than a note. It's a promissory note payable in accordance with its terms. And its terms did not include any obligation on the part of the trustee to pay any money to the trustee. And it did not include a term that would make any payment to Mr. Crisson, however large, illegal, or improper, pardon me, because all Mr. Crisson agreed to do was to ask the trustees to pay Mrs. Marshall. And in fact, that was always impossible because it was a discretionary Bermuda trust, and a discretionary Bermuda trust for a class of beneficiaries does not generally allow you to pay a third party. And that was the fear of the trustees. And that fear was expressed to Mrs. Marshall, and that's why it was never given as a guarantee. And the terms of the...
Just a moment. You're going too fast for me.
I apologize. I'm usually accused of going too
you
slow.
seem to be introducing new points. The trust was a discretionary trust. In whose favor?
Mr. Crisson's.
Right. Anybody else?
At one point, it was his daughter and I believe his wife.
But at the point we're concerned with,
it was him and his daughter, I believe.
Right.
But certainly him.
Yes.
And so, pardon me, Manuel, I don't mean to interrupt, but I may be able to short circuit this. If you go through the affidavit, it's more or less common ground that there was an attempt to get the trustees to join the acknowledgement of debt and promise to pay Mrs. Marshall, but the trustees refused to do so. And the halfway house that was provided was the halfway house by which the trustees would retain their entire discretion, and it appears on the face of the document, whether or not to pay anything to Mrs. Marshall. And the effect of what's all happened, just while we're on the subject, is that the money was paid to Mr. Crisson. Mr. Crisson paid 100,000 of it to Marshall, Diel and Myers. that 100,000 reduced the debt to approximately $150,000. And in accordance with clause 3, they have a $150,000 guarantee from the daughter. And so by the terms of the agreement, what has actually happened, I wasn't going to go through this in too much detail. What has actually happened is the terms of the agreement were being fulfilled. And that's why Mr. Crisson paid $100,000 over.
You said that the trustees were not able to make a payment to MDM under Bermuda law. I'm not quite following that. If the beneficiary or a beneficiary of the trusts asks them to pay in order to satisfy a debt that he owes, are you saying that the trustees can't do so?
I'm saying that was their position.
No, and I'm not asking you what their position was. I'm asking you what the law of Bermuda is.
My understanding of the law of Bermuda would be that they could make a payment to a third party on behalf of a beneficiary.
Precisely.
And that was not the view taken at the time. And that is why the wording of clause 2 was put in the manner that it is, because the initial, and I'm speaking from the evidence which is in Mrs. Marshall's affidavit and Mr. Crisson's affidavit. The evidence was that it was the intention to join the trustees who would give a guarantee, and what actually took place was that Andrew agreed, or Mr. Crisson, pardon me, agreed to ask.
Well, you say that the trustees thought that they couldn't pay, but what I've got from the quotation from the affidavits is that Mr. Crisson said that the trustees were squeamish about paying as much as 400,000. That's a different point.
Well, that's because he asked them, and they said, well, we don't want to get involved in all this. We'll give you the money, and then you pay it to whomever you think is. And then he paid the 100 grand to Marshall, Diel and Myers, leaving the 150 for the guarantee. And that's the guarantee they've sought to enforce.
Matter, but there is a difference between saying we don't want to pay and we don't think we can pay.
Well, if I might, on this point, what the agreement says, it doesn't really matter what the negotiations were. The agreement is unequivocal. It says Andrew agrees to ask them. I keep using his first name. I apologize. Mr. Crisson agrees to ask them.
Yes.
They then exercise their discretion.
Did he ask them?
Yes. That was a common position, I think, until the amended writ appeared. Georgia Marshall wrote to them. Andrew wrote to Georgia to say, I'm having trouble with the trustees. I'm going to get them to pay me. There didn't seem to be any dispute that he had asked them. They became worried when she asked for 400, when it's common ground that she was only owed 250.
Right.
They have included in their amended claim, pardon me, a line that he didn't ask them, but they have no way of knowing that. And it appears to be contrary to everybody's evidence. The squeamishness was about how it was all unfolding.
Right. So the position is he agreed that he would ask them.
Mm-hmm.
You say that he did ask them.
Yes.
They weren't prepared to pay at any rate 400,000 to MDM.
Mm-hmm.
And he then asked them to pay to him, and they did.
Yes. And asking them to pay him is not a breach of the agreement.
Well, if you promised to ask them to pay MDM, is it not a breach to ask them to pay somebody else?
If you once they refuse to pay MDM, no. And in fact, he didn't take the money for himself. He paid MDM in a manner that would allow the agreement to be fulfilled.
Right.
If you follow the steps of the agreement, Andrew paid them. Mr. Crisson paid 100 grand. The next step is clause 3, which is a guarantee from his sister and his mother to pay them once the apartment in New York is sold. It's on the market. It'll be sold in due course.
Mr. Hill, could you excuse me, Mr. Hill, could you give me the page number in the exhibit, because I'm working off the cloud where the agreement between Mr. Crisson and MDM is said to be?
It's in the affidavit evidence that apparently is not before your ladyship and your lordship today, which is deeply unfortunate.
Yeah, well, why is that? Why are we not given the relevant material? It seems to be happening.
I gave some materials to Mr.
Yes,
Coelho last week when the first hearing was coming on, and I don't believe I don't believe a sufficiently large number of copies were given to provide them to the judges who were abroad. Mr. Coelho, I must say, has made something of a monumental effort to get us to this point. I'm quite happy that added to the insult is that my scanner hasn't been working. And so I can scan the extracts from the...
Well, we have in fact got the agreement because it is referred to in the judgment of the Chief Justice.
Actually, that's correct.
Yes.
Mr. Hagen refers to it in detail.
But we don't have it as a separate document.
Not at the moment. I'm happy. I can get them. I believe my software guy has just got off my. He was removed, fixing my computer.
Well, speaking for myself, I'd be very grateful if we could have a copy of the agreement emailed over to us.
Okay.
My lady, if I might just make a point here, if you have the submissions which I filed in opposition to Mr. Hill's application,
Yes, I have those.
if you have those, and if you look at tab 5 of those submissions, you will see the agreement in question.
Thank you very much. Thank you.
Yeah.
And if one regard has a quick look at that agreement, clause 1 provides that until the judgment is received from the learned duty judge, Mr. Crisson will make payments of $1,500 per month, which was largely complied with. It's certainly the sum owed was reduced. When the judgment was finally given, and judgment was given some 18 or 19 months after the last hearing date of the trial, Mr. Crisson he guarantees that he'll ask. And then the trustees are then, the discretion of the trustees is then expressly recognized. And it said that they may or give some, none, or all of the money due under the acknowledgement of debt, which, by the way, is not the same sum that was due under the retainer. So this is a different number than was in fact actually due. Item number 3 is that in the event that the trustees do not provide a sufficiently large sum of money to pay off the entirety of the debt, then they can rely on this guarantee, which they get. What the guarantee amounts to is $150,000 upon the sale of the apartment in New York. That apartment is on the market. And in fact, part of our case is that they have relied on this agreement by writing to the daughter and the mother and the owners of the apartment seeking to enforce the guarantee. That will then provide them with a further $150,000, which will leave a very, very small amount due, which by virtue of the terms of clause 4 will be paid by further installment by Mr. Crisson at $1,500 a month.
Who owns this apartment?
It is owned by Mr. Crisson's daughter and his mother, and they have executed a guarantee in favor of the...
Yes, I see.
Could you confirm, is this the agreement dated the 16th of January 2018? I don't have tabs in the document. I've really got page numbers.
I think it's the 22nd.
22nd.
It's the next one down.
Tab
Page
5.
7.
I've got the 16th of January 2018 at tab 5.
Yeah,
Well, you want to go one page down.
One page down, right? I've got that. Thank you.
And that's that's not the agreement. Your ladyship can see that it's not signed. That was a proposal. So in fact, I would say that document's inadmissible and amounts to parole evidence of the contents of a contract. But the contents of the contract are explicit, and so we don't need to go backwards and have a look at what the parties were thinking at the time. And it says, with respect to the shares, with respect to the above stated debt, and it's a claim in debt. This is a simple matter. It's a claim in debt. Clause 1 reads, with respect to the above stated debt, I confirm that I will, I haven't got my glasses on. I will begin making weekly payments of $346.26 based on a $1,500 a month annualized until the judgment of the court is rendered. The payments will be made by way of attachment of earnings so that the funds are paid by the payroll clerk of Crisson Limited, which is a family jeweler business on the island in which Mr. Crisson used to have an interest. Directly to the firm, my first payment will be made on January the 31st. And payments were made under that clause. I cannot say that all of them were made, but certainly the majority or even a supermajority were made. The next obligation is I guarantee that upon completion of the case and the rendering of judgment, I will ask that the trustees of the Andrew L. Crisson Trust to exercise their discretion to release to the firm from the net equity of Mirabeau, that's the former matrimonial home that was owned by that trust, which was sold. And so the whole litigation was about the proportions in which the net proceeds of sale would be distributed. Sufficient funds to clear off my debt to the firm. If there are insufficient funds received from the sale of Mirabeau, or if the trustees do not exercise their discretion in my favor, then a guarantee from the owners of the New York apartment will be relied upon in accordance with the charge over security guarantee dated. And that there is a charge over security guarantee, and it is signed by the relevant parties.
Who are who?
The
mother, the daughter, and then Andrew and his brother sign it as well. All
And
four.
is
So
that
parties,
in the bundle? Is that in the bundle?
yes.
What page?
No.
And not in this bundle, it's in the evidence. It's not in dispute. I don't think my learned friend would say that it was disputed, that there was a guarantee provided. Is that correct, Mr. Pashai?
I don't have that document before me right now, so
Is it your position that it doesn't exist?
I haven't seen it, Mr. Hill. I don't have it before me right now.
Okay.
But the apartment was
Well,
owned by the mother.
I will get a copy of that.
Yes, helpful if we had the relevant documents.
Yes, I have to say that may be my fault. It's Mr. Coelho has made a monumental effort to get us this far, and I think I provided it.
But the apartment in New York is owned by the mother and daughter and a brother.
No, the mother and daughter own the apartment in New York.
Right.
And they executed the guarantee, and the guarantee is for $150,000. I will provide your lordship with the documents that make that point good.
Right.
And then that gets you down to the change, which may be a few $1,000s. I have no idea what the outstanding balance is.
So, I mean, to cut this all short, you say all that he agreed to do was to ask the trustees to pay sufficient to clear off his debts to the firm. He did ask the trustees. They said, no, thank you. You say that that meant that in those circumstances he had fulfilled the agreement, and the trustee, he was entitled to ask the trustees to pay him, and B, they were entitled to do so.
I would almost be able to go so far as the trustees had no other choice but to pay him. Who else would have
wasn't there another beneficiary?
Well, the daughter, I believe, was still a beneficiary at that time.
Yes, so they could pay
one or
the
other of
daughter.
them. But the disposal of the money, I will, but I don't need to go that far. They were entitled to pay it to him.
Yes.
And then they've then relied on that guarantee. They've written to the guarantors and said, please pink up when you sell the apartment. Those letters, by the way, coming after the issuance of these proceedings. And other steps have been taken to enforce that guarantee, which took place before these proceedings. That's
just pausing there
again,
a moment.
Common ground.
Yes, yes. Just pausing there a moment, leaving aside the question as to what was or wasn't in the pleadings, what the Chief Justice has in effect determined is that it was arguable that the MDM had an equitable interest of some kind in the monies that ended up, the 400,000 that ended up in the HSBC bank account, because, as the trustees knew, Mr. Crisson had agreed to ask them to pay the firm. They had not done so, but they had then paid Mr. Crisson, which was inconsistent with the agreement, and that therefore there was an equitable interest because, and this appears to be part of the exercise, these monies represent monies recovered by the solicitors.
Well, two things, or maybe a few more than that, actually.
Yes.
The reason that the learned Chief Justice gives for what he says, and what he says doesn't say that there's an arguable claim to proprietary interest. He says it's arguable that that's what they say. But
well, he can't
so,
mean it's arguable that that's what they say, but it's not arguable that that's true.
Yes. And then the next stage is he based it upon the breach by Mr. Crisson of clause 1. And I say there was no breach of clause 1. Clause 2, pardon me.
Clause 2.
And there was no breach of clause 2.
That's breach on the proposition that if you promise to ask and they say no, promise to ask to pay the firm and they say no, you can't then ask to say, well, pay me.
So that I can pay the firm.
Yeah.
In order to allow the agreement. He didn't pay the firm nothing. The first thing he did with the money was pay the firm. And he's got other creditors. And he paid such a sum of money that would allow the agreement into which everyone had entered to be fulfilled in accordance with its terms. So I say there was no breach. That's been our position from day one. And nor is one alleged in the statement of claim.
But just help me on this. The authority to which the Chief Justice referred indicated in broad terms that a solicitor may have a lien for his costs in relation to sums that the solicitor has in whole or in part, the solicitor's efforts have in whole or in part recovered.
Yes.
I'm having some difficulty in understanding in what sense it is said that the money that the trustees had was recovered by the solicitors.
Your Lordship makes another point that I make. The monies that the trustee had, he had before the litigation started. The litigation was about the proportions in which it was to be handed out. Now,
well, wait a moment.
Before we get to that point.
No, I'm afraid I can only do one point at a time. Can we keep on this?
Let's start with the first one I was going to say about what the learned Chief Justice says about all that, is when he looks at the case involving the solicitor's lien in the Supreme Court, it is nothing, it has no bearing, no resemblance to what occurred here. That may be because the learned Chief Justice has not ever been a solicitor in England taking part in the small claims traffic accident scheme run by Legal Aid. But a large number of solicitors are a member of a scheme in which they promise to each other to make good on costs obligations. It was the attempt to go behind that scheme and pay to the litigants what would have been the cost that they paid to the claimant solicitor under that scheme that created the unconscionable activity which gave rise to an equitable proprietary claim. Now, I presume somewhere in that story someone pleaded an equitable proprietary claim. In this case, no one has, but the solicitor who paid the money to the injured party, so the solicitor's acting for the insurer, and there's a solicitor acting for the man who gets whiplash, as almost everyone does in these things. They are members of a scheme which help to allow costs to be paid, and it's all in the ruling by I think it's Lord Bridge. And there are promises between the solicitors which exist through that scheme. And the costs that the the claimant solicitors were allowed to go and get from the solicitors, not from the litigant, from the solicitors, are the costs that they paid to the litigants in breach or quasi-breach of that scheme. Because they both signed client care letters, what we call in Bermuda, I think, engagement letters or retainer letters. They both signed client care letters, which were all organized under the scheme. So the equitable rights in that case arose because there was a promise between the solicitors to respect its terms, and the solicitor hadn't. In this case, the solicitor is replaced by the trustee, and the trustee expressly refused to promise to take part in the whole scheme and said, I can't do that. Whether he was right or wrong matters not, because everyone accepted that he could give either no money or all of the money to the plaintiff, the respondent in this appeal.
Yeah. So you say that case is completely different on its facts.
I don't think I'd say completely, but I'd say it's not helpful to us. It's a case about solicitors' liens over the
Well, yes,
of
but it
litigation.
contains what the Chief Justice regarded as a statement of principle, which appeared to contemplate that at any rate in certain circumstances, solicitors would have a lien on sums which they were responsible for recovering. Now, in the present case, as you say, the property in question, where is the Mirabeau property? Is it in Bermuda?
Is your lordship familiar with Bermuda?
Yes.
It's on Harrington Sound, I believe. Or it's either, I went to Mr. Crisson's house twice in my adult life. He had one on South Shore in Tuckerstown next door to his parents, and he had another one on Harrington Sound, and as you're going to the airport, just near Leamington Claves.
Yes. Now, that property was held by trustees in trust for Mr. Crisson and his daughter. So the question might arise as to whether the solicitors could in any sense whatever be regarded as having recovered that property. Was there an issue in the divorce proceedings which related to how that property or the proceeds thereof should be settled out?
Yes.
Right.
There was an issue joined as to how and in fact the house had been sold quite early doors, as they say in the football circles.
Sorry, it had been sold what?
It had been sold very early doors.
Oh yes.
And, so they were simply holding on to the proceeds, and they had the proceeds pretty much throughout the litigation. But there was an issue between the parties as to what proportion those proceeds should be split out. But Mrs. Crisson's claim was for a sum well in excess of that. Her claim was not for the proceeds, but that is how her claim was dealt with. So there was an issue about what was to become of the proceeds, and the judge made a ruling as to how they were to be divvied up. Because the trustees...
I suppose it could be said that if and insofar as it was ruled that he should have X% of the proceeds, the solicitors had not as it were recovered, but had prevented from removal that share of the proceeds.
Correct, because at the beginning of the proceeds, he was entitled. At the beginning of the proceedings, he was entitled to all of the proceeds. Yes. And at the end of it, he was only entitled to half.
Yes, but he was at least entitled to half.
Yes.
Yeah. Okay.
That is a point that I would have made in the substantive appeal.
Well, I'm not sure it's a point in your favour, because it would appear
it's a point that could go either way.
Yeah.
It is a fact.
Right.
It's certainly not on all fours with the case of which I learned it, where there's genuine litigation proceeds. What we have here, and a divorce is not, because of the way it's done, this inquisitorial way in which it's done, and it's a bit like an insolvency in some ways, because you find the assets, work out who owns them, and then you work out how they're to be distributed. And whether or not that constitutes the proceeds of litigation is or will be a live question in the actual appeal. My argument would be that it isn't, and your lordship has picked up on that particular.
I would have thought that a divorce lawyer who secured for his client payment of $1 million would regard it as a recovery that he had achieved. But
and the other point is good, is he failed to recover the other half.
Well, yes, but I mean,
there are tight arguments on either side, but it's
there may be.
I don't think it's on. If we're looking at leave to appeal, And that would be something that would be dealt with in the strikeout application. This appeal, because it was the first hearing, I'm submitting that the judge should have gone beyond what he did, and he should have examined whether or not there was sufficient evidence on the pleadings in the affidavit to support the suggestion that this was a proprietary claim. And he did not do so, and in failing to do so, he erred in principle. Had he done so, he would have seen easily that no proprietary claim was ever made in the writ. And in fact, he would see that there is no breach of the agreement by Mr. Crisson, because clause 2 does not oblige him to make any payment and does not prevent the trustees from paying him.
Right.
And in
So
actual
in
fact,
short,
if you follow the agreement, that's the logic of what I'm doing here today.
Yes, you say that you have an arguable claim that the Chief Justice should not have determined that there was an arguable claim to a proprietary interest, either that there was one or that one was pleaded. That's what it amounts to.
Correct.
Right.
And he didn't go that far. And in fact, he
What do you mean he
described
didn't go that far? He did.
Well,
say
what he did, if you look at the ruling, the ruling is couched in terms of this word might be used. Mr. Hill says this was put in as a pasting error, and it was never intended to make a proprietary claim, and that was something thought of later. And he says, well, if you look at these words can be construed as suggesting that a proprietary interest. He takes the word fund, for example. In fact, the word fund is never used. It's always used in the plural. Now, everyone knows that there's a difference between a fund and funds. One is fungible and uncountable, and one of them is countable. And you can't have funds making up a fund. There's no fund identified. The order itself freezes the contents of bank accounts and not a fund. And he had no basis upon which to find that there was a proprietary claim advanced at all. And I say there was no legitimate claim advanced at all, because there was no breach of any agreement to which the parties were then bound by virtue of the general rules of acquiescence or affirmation.
Right.
And once you rely on the terms of a contract, you are not you do not accept the repudiatory breach, so the contract lives. You may be entitled to some damages, and there are no damages here because what was left behind, in fact, allowed the agreement to proceed into the future and, in fact, pay them everything they needed in accordance with its terms.
Right. Now, that's the substance of the matter. But what about the timing of your application?
Well, what I say about that, and I'll put it quite simply, is the injunction, if I might call it, or the directions given by the learned Chief Justice through his registrar, was that while the Bolkaya application was extant, that I was to take no further steps in the proceedings, but I would be able to take all steps necessary in the variation application. It is my contention that an application for leave to appeal is not an application which is made in the variation application. And general principles, again, explain to us why that might be. And that's because the moment that the learned Chief Justice gave his order, he became functus officio in relation to the variation application. And the mechanism by which the application for leave to appeal is made is by a new notice of motion under the jurisdiction contained in the Court of Appeal Act and the rules made thereunder. He's not reviewing his order. He's simply deciding whether there is an issue in the order that is capable of giving rise to an arguable appeal. And
well, a number of points arise out of that.
Yes.
What the registrar, on the direction of the Chief Justice, said was that the Chief Justice directs that the variation application should proceed as previously directed, and then, save for this variation application, no further steps will be taken in these proceedings until the issue as to whether you could act had been determined. Is that second passage really a prohibition with the force of an order against filing a notice of intention to appeal, or simply a statement that nothing will be done by the court at first instance until the question of your ability to represent Mr. Crisson is determined?
no further steps. The people who take steps in litigation are the litigants.
Well,
We take them
not
by,
only.
we take them by filing summonses. The court very rarely takes steps without someone asking them to do something.
Well, the court takes steps all the time by fixing things.
Yes, but they couldn't fix anything in
Determinations.
this because this was functus officio. They couldn't do anything further in the variation application. It was dead.
Mr. Hill, if you were going to challenge the Chief Justice's ruling, the first port of call in normal circumstances would be to seek leave to appeal from him.
Correct.
To that extent, he wasn't functus. He was still there as the first decision maker on an application for leave to appeal. Did you at any time go back to the Chief Justice and say, I'm concerned about the order you made previously. We want to appeal your decision. Can you please confirm that I may act in relation to an application for leave? Did you do that?
I did not, but I think it's two important things are worth bearing in mind. At that time, the ruling, the directions that His Lordship's referring to in this email are directions that were given on the 9th of April, which said that the strikeout application, not the strikeout, the set-aside application would be determined as a matter of urgency the moment the courts were open. And so I was content to allow the set-aside application to run. When that was blown up, and we still haven't had a set-aside application to this day, which is, to my view, is an enormous deprivation of justice to Mr. Crisson. He's had those money seized now for what will be over a year without a chance to go and explain his complaints. And as I've just outlined, his complaints are not meaningless. He has genuine grounds of appeal. In any event, I thought that was going to happen almost immediately. It didn't. To my mind, the issuance of a notice of motion for leave to appeal under the rules of the Court of Appeal is not a step in the application to vary the injunction. You make that application to the Court of Appeal, to the judge at first instance, because the Court of Appeal rules tell you to, not because of anything in the Supreme Court. And it does seem to me to be at least arguable, and I go further than that. I'd say that it is one of the natural consequences of the doctrine of functus officio, and indeed res judicata, but that has more complications, of course, today.
Did you at any time before you got the decision in your favour on the Volkia point share your concerns about being hamstrung in relation to an appeal? Did you share those concerns with MDM? Did you say we're intending to appeal, but at the moment I can't? Will you?
I had told MDM that I would not discuss the terms of the order of the variation itself with my client. I ceased speaking to my client, and every time any question in this matter arose, Mr. Pshai intervened to say Mr. Hill is not allowed to take that step. So I gave what I call an undertaking, and what Mr. Bell says isn't one. I promised not to speak to my client about anything after we got the ruling. And speaking about an appeal is doing something which I said I would not do, and is something which I believed I was prohibited from doing by the terms of that order. Now,
so you didn't say to MDM, we're intending to appeal, but at the moment I can't do anything about it. I
had no instructions to appeal, and I couldn't get any because I wasn't even allowed to discuss settlement.
Yeah.
I was complained at for trying to agree the final order,
Yeah.
and I was attempting to get additional new lawyers for Mr. Crisson, and I ended up having to do the Bolkaya issue myself at my own expense. And I had a threat of an ex parte application being made against me, an ex parte application which was likely to be successful in large measure. And I was seeking to avoid that at all costs. And so from the moment we received the judge's order, I ceased speaking to my clients at all about any aspect of this matter. That's what I took that to mean. And that is what I believe my learned friend took it to mean. Because when I asked for the audios, for example, Mr. Pshai wrote in and said, Mr. Hill's not allowed to ask for the audios. He's not allowed to do anything. And I had repeatedly said to Mr. Prashai, I will not do anything. Please don't go and get an ex parte order, because the person who's going to pay for it is me. And that is something which I devoutly wish to avoid. And so those two elements, one, an application for leave to appeal is not an application in the variation application, it's an application in the proceedings. And two, I was confronted with a genuine threat that an ex parte order would be obtained against me, presumably on notice, it must be said, that I would not be able to legitimately resist, and that a cost order would likely be made against me. And I was really, really keen on avoiding that.
I don't quite understand why you couldn't simply write to the Lord Chief Justice with a copy to MDM saying, as we all know, the time for an appeal, or the time for an application for leave to appeal, expires in 14 days' time. I anticipate that my client would wish to appeal. It's quite wrong that time should be allowed to expire upon the hypothesis that I can't advise him. Will you confirm, Lord Chief Justice, that I am at liberty to discuss the question of appeal and to file a notice of motion to do so if so advised?
I could have taken that course. That would have generated a great deal of correspondence, I imagine. I took the view that the ability of the appeal court, the Court of Appeal for Bermuda, to extend time if I gave good and substantive grounds for not filing the appeal, and the good and substantive grounds upon which I relied today are that there was a direction telling me that I could not take steps in the proceedings, and that could all be resolved by an application to seek an extension of time if and only if, because of course, if it had been found that I had information that was confidential, then it was right and proper that I not make an application for leave to appeal. I agree, and I agreed with the proposition that if I had confidential information, I should not be involved in this case. So if I had confidential information, I shouldn't have been making an application for leave to appeal. And so I didn't. I allowed that to run its course, and I got my leave to appeal application in within 14 days of the ruling.
Yes. Now, just there's some more problems that arise in relation to that, because the rules of the court say that you should apply for leave to appeal to the Supreme Court first.
But the practice in Bermuda is that when you've missed the time, you need, the only person who can extend, the only court that can extend time in the Court of Appeal is the Court of Appeal. These things are usually done by an application before a single justice. And then they send you back to the judge to get leave to appeal. In the Pedro matter, your lordship may recall, when I was instructed, we decided not to do it that way. We decided to do it by application before the entire court, the whole court, and then to proceed immediately to the appeal, which ran into the buffer slightly. And then, of course, I felt that my instructions had changed, that I was professionally embarrassed and withdrew. And Mrs. Pedro has gone about her business in her own way. But that was how we did it that time. But that was not the practice that has been adopted by the court in general. And I'll give examples. I was instructed in an appeal, and the last day in which the time to appeal would expire was on a day when Hurricane Nicole passed overhead and the court offices were shut. And so I missed the day to a file, and I had to apply for leave to appeal out of time on the Monday after the hurricane had passed over and the offices were open, which I duly did. I got in front of the Chief Justice sitting, the previous Chief Justice that is, sitting as a judge, as a single justice of the Court of Appeal. He granted leave, and then I appeared back the following week in front of the judge before whom I needed to seek leave. Now, the practice in England, when you have these sort of, this is a sort of amalgamation of a number of applications for extension of time, for leave itself, and I had rather hoped to move on as quickly as we could to the appeal because of the amount of time that Mr. Crisson has been without his money. I don't think it can be said, with all due respect, that the policy that I adopted, particularly with the threat of an ex parte injunction hanging over my head, was unreasonable. And I submit, with all due respect to the learned Justice of Appeal, that it does indeed constitute good and substantial grounds for not having filed on time. And that is that the application was over and the judge had given an order that I not do so.
Right.
That is what that order means.
So the position is that you should, in accordance with the rules, have applied to the Chief Justice for leave to appeal within 14 days. You didn't do that in 14 days, but the rule in relation to 14 days is laid down in the rules of the Court of Appeal. So only the Court of Appeal can extend the time.
Correct.
Yes.
And I believe that submission is axiomatic.
Yes. Not sure what that means.
For those of us who studied maths.
What?
It's an axiom that only the Court of Appeal can extend its time.
Well, it's a proposition which is in accordance with the rules. If that's what an axiom is, fine.
Yes, that's what an axiom is.
Yes. Okay. Yes. And we're now in the curious position. And you, in theory, Mr. Crisson could himself file an application.
Yes, he'd have to do it himself.
Yes.
And I flatter myself to think that I'm better than nothing. And Mr. Crisson was unwilling to do it himself. He
Yes.
needed help.
What about other lawyers?
There were no other lawyers that would act for him. And when I say none, Mr. Crisson and his family are important, or have been important businessmen here, and they have trusts and so on. And everybody I spoke to raised a conflict that they would not be prepared to act. There might have been lawyers with whom I'm not terribly familiar who might have been able to do with it. But I can tell you that Conyers, Appleby, Wakefield Quinn, Marshall, well, all of the firms who normally deal with this sort of thing were unprepared to act on Mr. Crisson's behalf in this matter. And this matter had become rather infamous because of the acrimony with which the divorce was pursued. And so I took the view, and I think reasonably, and I think correctly, I submit reasonably, and I submit correctly, that the directions given by His Lordship, the learned Chief Justice, in fact, on their face, it's true that I could have asked for an exclusion, an extension to be able to file a leave to appeal application, but the mechanisms were available to me by doing this. And this is in fact a cleaner way of doing it, because it didn't involve any litigation which would have seen me hold before the beak and an ex parte order against me and a cost order awarded against me. And in fact, those were the two elements that were in my mind. And it is hard to perceive how that can be viewed as not a good reason for going on time.
Right. You said a moment ago that something happened on the 9th of April, and I'm afraid I didn't make a note of it. What was it?
Well, on the 9th of April, His Lordship gave his ruling that the variation would occur on the papers. And there are a number. I have an application extant to recuse, for example, the registrar who worked on the Crisson file while she was employed by Marshall, Diel and Myers. And I have an application. I'm not making friends in this story, that's for sure. I have an application to recuse the judge who made the order, because she was the trial judge and she made negative comments about a number of people, one of whom being my client, in her ruling.
No.
Those matters are now, it was in that 9th of April ruling that the learned Chief Justice said all of those matters will be dealt with on the day of the strike, the day of the set-aside application.
Right.
The consequences, for example, if the registrar is recused, then of course my argument would be that all of her decisions would be vacated, and one of her decisions was to send the matter to the learned puny judge, and then therefore the learned puny judge shouldn't have been hearing this matter in the first place, and that's another mechanism by which I attack I have a lot to say, if I can put it that way, about the manner in which how we got here today occurred.
Yeah, well, that's for
I'm not going to say anything about it today.
No, don't. Right, well, I think we better hear from your opponent.
Yes, my lord. Can I first of all say that the correspondence that Mr. Hill relies upon as purportedly prohibiting him from making an application for leave to appeal.
Your voice is fading from time to time. I don't know how close you are to a microphone. You look miles away from it.
All right, let me come closer if I.
At least I can see you now.
Right, and can you hear me any better?
Yes?
Right. Okay, so the point that I was making is that the correspondence that Mr. Hill relies upon as precluding him from making an application for leave to appeal, the Chief Justice's ruling of the 7th of May, is dated itself the 26th of May. He attaches that in his second affidavit.
Well, he may do, but we haven't got that.
I sent something to Mr. Quillo the last week to bring to your attention, and I'm not sure if Mr. Quillo did so.
Could you tell me again what it is you're referring to?
I'm referring to the correspondence that Mr. Hill relies upon for the proposition that he was not permitted to take a step in the action so as to preclude him from making an application for leave to appeal. And my point to you is that the correspondence that he relies upon is dated the 26th of May, 2020. The time limited for making the application for leave to appeal expired on the 21st of May. So the correspondence that he relies upon postdates the time limit for him to make the application for leave to appeal.
Is his correspondence with whom?
His correspondence with me and the Supreme Court.
And where do we find that in the documents that we've been sent?
Well, you will find that as an exhibit to his second affidavit that he has filed in relation to this application, and I don't know if you have that, but I also sent it separately to Mr. Quillo last week to bring to your attention the
Okay,
fact
what page number? I have a hard copy of the exhibit to the second affidavit of Mr. Hill, dated the 9th of November. What page number are you looking at?
looking at page number 23.
And so just repeat your point.
My point is this, my lady. So if you look at page number 23, and he has highlighted the portion that he relies upon, where he writes on the 26th of May, 2020, to the registrar, the hearing before Justice Dolan predates that. He relies upon my email to the Supreme Court of the 26th of May, 2020, where I say to the registrar, the hearing before Judge Stolen predates Mr. Hill's involvement in this matter, which started on the 19th of December. Furthermore, he has been directed to take no further steps until the conflict application has been heard. And of course, no further steps does not include steps in relation to the variation application. So my point is,
I'm terribly sorry. Where is this on the? Have we got this on the cloud?
Yes, it's a document on the cloud called MDM. It's a series of emails that are highlighted.
I'm sorry, Mr. Coelho, I don't know what you're referring to on the cloud. We've got something called Registrar's Email, 21st of April, 2020.
No, we have got something. I don't remember seeing it there before.
No, this was just dragged over from the email sent by Mr. Pachai.
Well, what's it called on the cloud, please?
MDM.
MDM.
I don't have that.
You may have to refresh your browser.
It's only very recently been added.
Mr. Quillo, is this the email that I sent to you last week?
An email dated 10th of November.
Okay, if you refresh, it's there. Well, I've got, it was put there just this morning
Yes.
or your afternoon. Put there a moment ago. Okay.
This is the attachment from your email of 10 November, correct, Mr. Pichai?
Yes.
Yes.
Where I said, would you please make this available to the Court of Appeal?
3 of Mr. Hill's exhibits.
So, my lady, the point that I'm making here is that the correspondence that Mr. Hill relies upon to justify his failure to make the application for leave to appeal post-dates, first of all, the deadline for him to make the application for leave to appeal, which was the 21st of May, because that correspondence is dated the 26th of May. But more importantly, Mr. Hill himself, in the correspondence that I sent to Mr. Coelho, which is a response from Mr. Hill to my email, makes it very clear that he did not himself feel constrained in any way to act in relation to the variation application, including, in my submission, an appeal from the Chief Justice's ruling.
Where do we get that? Where do we get that from?
Okay, so this is what I sent to Mr. Coelho, because Mr. Hill, sorry about it.
Sorry, what did you send? What are you talking about? What did you send to Mr. Hill?
I sent to Mr. Coelho the response from Mr. Hill dated the 26th of May, 2020. Does your lordship have that?
Yes.
All right. And you'll see that he is responding to me and to the registrar. And he says, "Dear sirs, to be clear, neither my firm nor I have ever been directed to do or abstain from doing anything, and I remain the attorney of record. I have offered an undertaking to Mr. Pichai on numerous occasions, which has not been taken up. I have told Mr. Pichai that I will do nothing but advise in relation to the variation, because I was allowed to handle that by the Chief Justice." So there, my lord, is an admission that he was certainly able to advise in relation to the variation application, including an appeal from that ruling. He goes on to say in the next paragraph, "I have told Mr. Pichai that I will do nothing other than that, and I will be good to that promise. I have already ceased communicating with them about the matter other than to advise on the substance and effect of the Chief Justice's ruling in all of its aspects." And I can tell your lordship that Mr. Hill never once wrote to me to say, my client is dissatisfied with the judgment or the ruling of the Chief Justice, and it is his intention to appeal that ruling. Nor did he write to the Supreme Court to seek the permission from the Chief Justice, if he felt he was constrained, to make the application for leave to appeal. So he indicates in all respects, he was free to act and advise in relation to the variation application.
Well, hang on a moment. All he says is advise. He doesn't say that he's able to act. There's a difference between advising and filing a notice of appeal.
Well, he says before that, because I was allowed to handle that by the Chief Justice. So obviously handle means act. And this correspondence comes after the deadline has already expired. And your lordship is right. If he had any concern about it, he could have raised it with me. And it was clear to me, I had made it clear all along that he was able to do whatever he wanted so far as the variation application was concerned. And if he felt constrained, he could have, of course, made his position known to the registrar and to the Chief Justice. And he never did any of those things at all.
So when you say that you made it clear that he'd do what he wanted so far as the variation was concerned, was there any discussion about an appeal?
No, never. What I said to him was that he was not permitted to go and ask for the transcript which predated his involvement, and also because it had nothing to do with the variation application. But he was always free.
Which transcript?
The transcript of the hearing before Justice Stoneham on the 13th of December, my Lord, 2019. But as far as the variation application was concerned, there was nothing to prevent him from applying for leave to appeal within the 14-day period.
Well, he appears to say in the first sentence that he's never been directed to do or abstain from doing anything.
Yes, as far as the variation application is concerned.
Well, it actually says anything.
No, my lord.
I think that might have gone a bit far.
Right.
Now I can deal, that is the position as far as the time limit is concerned. And I would venture to add that had he approached either me or the court, there would have been very little question, but that he would have been permitted to make his application for leave to appeal. Because the Chief Justice might have been functus as far as the substance of his ruling is concerned, but he could never be functus as far as an application for leave to appeal that ruling is concerned. And we are not here talking about a delay of some days or some weeks. We are talking about a delay of over 3 months. Does your lordship wish me to deal with any of the merits of his application in terms of the proprietary claim?
Well, I think we would like to hear something. I think we would like to hear something about that briefly.
All right. Well, briefly, as far as the assertion that Mr. Hill makes that no proprietary claim was made in the original writ, the position is that when the Angel Bell application came before the Chief Justice, which of course is the only thing that he was concerned about in his ruling of the 7th of May. The draft amended writ was exhibited to the affidavit of Georgia Marshall. It was before the court. It was in the evidence. And that is the same draft amended writ that...
Hang on. It wasn't in the evidence. I didn't get a copy of it. Because of the issues in the Bokaya application, I was not provided with a copy of the amended writ until after the Bokaya application. I did not see it. And I make the point in my submissions that it's not fair that this ruling is being made on the basis of documents that have not been shared with me.
Yeah, we've taken that submission on board already.
Okay,
Well,
well,
all I can tell you,
I didn't want my understanding repeating the contrary. It's not submitted.
it was exhibited to the affidavit of Georgia Marshall
Sorry, which affidavit?
in relation to the variation application. Now, you will not have that before. I do not
What was the
believe
date
you.
of the what was the date of the affidavit?
My lord, I will find it for you in the ruling of the Chief Justice. That he deals with it.
Well, speaking for myself, I would like to see that affidavit from Mrs. Marshall. Because if that was before the court, it's clearly relevant for us to consider that.
Before the court,
On which she puts forward a proprietary and asserted proprietary.
Yeah. So this is Mrs. Marshall's second affidavit of the 18th of February. If you would have a look at tab 1 of my submissions, you will find the ruling of the Chief Justice of the 7th of May. And if you look there, at paragraph 23.
Well, is it beyond the bounds of possibility that we could be provided with a copy of Mrs. Marshall's affidavit, second affidavit of the 18th of February? I mean, one or other of you must have it.
Oh, yes, of course, we can do so.
Well,
I mean, I'm very happy to send it to Mr. Quayler.
yeah, thank you very much.
Make a note of that, and I will send it to you, but you will see. So, this is the.
while Mr. Shah is writing, I'll just say that this is an affidavit that was not before the judge who made the injunction. It was an affidavit.
This was the
before the Chief
affidavit.
Justice.
This was the affidavit before the Chief Justice in relation to the application which was before him, and I will certainly send it to Mr. Quayler. But if you have a look at this, at the Chief Justice's ruling, at paragraph 23, you will see that he refers to it and in paragraph 24, you will see the reference to the draft amended specially endorsed writ of summons, which is referred to in Mrs. Marshall's affidavit and exhibited to that affidavit.
Give me the paragraph number again, please.
24.
24. Thank you.
Well, they do indeed refer to that, but I have no doubt that when you send us a copy of the affidavit, it will have what the Chief Justice said in his judgment it contained, namely the proposed amendment. But the critical question is whether Mr. Hill ever saw it.
Well, first of all, let me tell you that I was not involved. Marshall Diel and Myers were representing themselves in relation to the variation application. Right, so I don't have the answer to that question. I can only assume that the affidavit of Mrs. Marshall, having been filed with the court, having been before the court, having been before the Chief Justice, Mr. Hill would certainly have been provided with a copy of that affidavit.
Well, Mr. Hill, did you have a
It had
copy?
nothing to do with the Balkia application.
Mr. Hill, did you have a copy of the, leaving aside the exhibit, did you have a copy of the affidavit?
Yes, I did not have a copy of the draft amended writ.
Did you ask for a copy of the exhibit?
No, the reason for not giving it to me was the Balkia, and we were working very quickly on the papers. And so,
well, sorry, you say the reason for not giving it to you. You have an affidavit, which is in proceedings in which you're representing Mr. Crisson.
yes,
It refers to an exhibit.
yes,
If you're entitled to act in the proceedings, you're entitled to see the exhibit.
yes.
Did you
That's
not
what I said.
say, I must have the exhibit?
I think I made a point about it, but the other point I would have made that a draft.
Well, you made what point about it?
This should not be happening without me having seen the affidavit, and that his lordship should not, without me having seen the writ, the amended writ, pardon me. And the other point I made was its draft, and that no application had been made to file it. It was.
Well, sorry, you say you made that point. The appearance in front of the Chief Justice was on paper.
Yes.
So somewhere there's a document in which you say I should have a copy of the affidavit.
Yes.
Is that?
Yes, it's in my submissions.
To the Chief Justice.
Yes.
Well, needless to say, we haven't got them. Could you?
There was a bundle prepared that contained all of these documents, which were before your brother Judge Bell, J.A. They have not got to you, this particular panel, pardon me. And that, I believe, is a function of my having not delivered a sufficient number of copies of what was in actual fact quite a large bundle. And that's a logistical issue that was caused. They would never have got to you because this hearing happened quicker than you're getting documents, I believe. And that is a snafu, which is
well,
my fault.
I should like to see a copy of your submissions to the Chief Justice, and for our attention to be drawn to the paragraph in which you say that you said that you hadn't got but should have received the exhibit to Mrs. Marshall's second affidavit.
Very well. I think the way I put it is, no decision should be based upon a document that I haven't seen.
Right.
That your lordship should pay no attention to it, because and in fact there isn't even an application to amend. There's nothing. It was simply a piece of paper. It had no standing in the proceedings because no application had been made. I wouldn't have been allowed to appear on that application because I was only allowed to appear on the variation, and so on. There were a number of issues in which this was being handled in a manner which I found bizarre.
Right.
It seems extraordinary to me too.
Yes, I follow that. Yes.
And that was the issue with that. I didn't mean to interrupt but there was a submission made that no decision should be made on the basis of a document I haven't seen.
Yeah.
Right. And I don't have the answer to the question whether he had a copy of the actual amended writ, but certainly he would have had a copy of the affidavit. So the position right now, my lord, is that we have a hearing before the Chief Justice on the 19th of January, during which he will determine the application for summary judgment on behalf of MDM. He will also determine Mr. Hill's application to set aside the injunction of the 13th of December, 2019. And in relation to that hearing on the 19th of January of next year, I should mention that the Chief Justice made an order on the 1st of October 2020, giving leave to MDM to file the amended specially endorsed writ of summons and statement of claim. And the court will see that at tab 7 of my submissions. And the amended writ, as now filed with the court, is at tab 8, and it makes the proprietary claim. And the legal position, my lord, as far as the amended writ is concerned, is that the amendments take effect from the date of the original writ, not from the date of the amendment. And I have exhibited at tab 9 the relevant extract from the rules, the commentary, the white book. So the complaint of no proprietary claim, in my view, is not well-founded so far as the hearing before the Chief Justice on the 19th of January will be concerned.
So, I mean, we seem to be getting to the situation where this is all going to come out in the wash in a couple of months' time, because presumably the application to set aside is upon the basis that there's no proprietary claim.
Yes, no breach of... Yes, no cause of action.
If that fails, well, if it's decided on that the injunction should be set aside, there's no need to vary it, because it's not going to exist.
And the application for summary judgment will be heard at the same time. So if the application for summary judgment is successful, that will be the end of the injunction.
So is the position that if we give permission now, it'll all be moot by the time any appeal falls to be heard?
That would appear to be the position now, my lord. It wasn't when we first started.
No. But if that's the position now, why are we, discussing these interesting matters?
Because when I filed my application,
sorry?
Pardon me, my lord, I interrupted you. When I filed the application in relation to this matter, no date had been fixed for the hearing of the set-aside application. And this appeared, if I might say so, a shorthand mechanism of having at least some of the questions which are live between us determined before an imaginary date which had not yet been fixed.
Yes, but we
granted over a year
we
ago.
are where we are, and we have to decide now whether we shall grant permission for the matter to come before the Court of Appeal.
Yes.
And if in practice it's all going to be determined before it can ever get to the Court of Appeal, what's the point of giving permission?
Because it is open to your lordships and your ladyship on this appeal, if we'd managed to get it into this session, to make findings based purely on the ruling of the learned Chief Justice that the injunction obtained does not give rise to either A, proprietary relief, or indeed B, Moreva relief. And that
you mean you're expecting us within this session, not only to grant leave, but to hear your appeal?
That's correct, and that was feasible. That was feasible before Mr. Bell, the learned Justice of Appeal Bell, pardon me, refused leave on the grounds that it was, in fact, it was going to happen tomorrow. So if leave had been granted 10 days ago, we were going to do the appeal tomorrow. Mr. Coelho will bear that out, I believe. That was my understanding of our position.
That's not factual. The matter went before a single judge for the issue that the court is now dealing with on the renewal application. So the exercise that took place before Justice of Appeal Bell on the 2nd of November would in fact have been this matter.
And that was only an application for an extension of time, not an application for leave to appeal. So the only issue which the court is concerned with today, as was the position before Justice Bell, was whether time should be extended for Mr. Hill to make his application for leave to appeal.
Well, wait a moment. I had assumed that we were dealing with both. The notion that we should consider simply an extension of time, but not whether, if time is extended, we should grant leave to appeal, is bordering on the absurd.
It is. There are two notices of motion. One construction that could have been given to my original, the notice of motion that I first filed for an extension of time. One construction upon it could have been that I had only asked for an extension of time, and so I filed another notice of motion seeking leave, and they were both heard. They're both before your lordships today.
But come back to the point that we were on a moment ago. As of the moment that we speak, that is today, the reality is that even if we grant you leave for an extension of time and permission to appeal, it is not going to be heard this session. This session ends on Friday. The next session is in March, although the court may have to sit on other matters before then. But if that is the position as it is, where in effect everything is now going to be determined one way or the other on the 19th of January, and an appeal can follow after that, why should we grant permission now, which will be fruitless?
And of course, my lord, may I just add?
Well, sorry, no, don't.
Were you asking me or were you asking?
No, I'm not asking you. I'm asking Mr. Hill.
Oh,
well,
right.
the answer to that question is that when the applications were made, the question of the set aside of the whole thing on the grounds of no cause of action, et cetera, which I've touched upon lightly this morning, had not been fixed. It has now. The only definitive question which his lordship is said to have answered is whether a proprietary injunction was obtained. And the only way I can attack that finding that there's a proprietary interest in these funds is through an appeal. And so the appeal is in fact not OTO's, because if there is a proprietary interest, that changes everything for all of the other creditors.
But it's only an interlocutory finding that it's arguable that there is a proprietary interest. That's not binding.
Well, then we're going to the next hearing is interlocutory as well, and it will be the question.
Yeah, well, our decision would be interlocutory.
Yes, of course, but it would be I'm hoping it would be different. And more
isn't the real problem, if I can come in here, isn't the real problem the practical one, that absent an appeal, the Chief Justice is likely to stick with his view as expressed in his judgment of the 7th of May, that the amended writ does justify a proprietary injunction. And that's the point I think you're making, Mr. Hill.
It is indeed, my lady.
That whether it's interlocutory or not,
I'm
he's
stuck
not
with it.
going to be likely, having had it all once argued in front of him, come to a different conclusion at the set-aside.
Correct.
May I just...
And that particular issue was raised when we were trying to settle the order and the difficulties with which I would be confronted. And your ladyship makes the point much better than I do. That is in fact why this appeal is different from the set-aside application which will take place, because it determines the character of the order made and what the plaintiff has to prove to an arguable extent in the set-aside application. If, for example, it's a Morava injunction, then the burdens of the issues that have to be proved to an arguable degree are different from the ones that need to be proved in relation to a proprietary interest. And if, when we come out of the room, the order stands, but it stands as a Morava, that has very different consequences for my friend, for my client, than if it stands as a proprietary claim.
But could I raise this question of both Mr. Pakai and Mr. Hill? If the issue is simply in the circumstances of the agreement between Mr. Crisson and MDM, there was no room for a solicitor's lien because it had been excluded by agreement or the subsequent agreement, which is Mr. Hill's argument. Why isn't that a simple issue that we could, or this court could decide here and now? I mean, it might involve a bit of procedural cartwheels, but if that's the simple issue, and perhaps it's not a simple issue, but is that what the issue is?
Yes, my lady.
No, my lady, it goes further. And may I just respond, please? So
yes, please do. I'm asking you too, Mr.
Yes.
Packer. I made that clear.
Yes, absolutely. But may I first respond to what you just said previously? And the Chief Justice was very, very careful in his ruling to make sure that he was not tying his hands or the party's hands in any way whatsoever.
Right,
And
what paragraph do I look at for that?
Right? If you look at, first of all, paragraph 11.
Sorry, can you remind me of the tab?
The tab is tab 1.
Thank you. Yeah, okay, I'm there. Thank you.
Okay, and it's paragraph 11, where you can see at the beginning, he describes the reasoning behind entertaining the Angel Bell application. And he says at the end of 11, nothing said in this ruling is intended to affect or prejudge the anticipated applications relating to A, the removal of Mr. Hill as counsel for the defendant, B, defendant's application to set aside the order of the 13th of December 2019, and C, plaintiff's application for summary judgment. And if your ladyship goes further to paragraph 25,
yes,
you will see the Chief Justice says there, subject to any further arguments to be advanced of the application to set aside the order of 13th December 2019, or the application for summary judgment. So all of these arguments that you have heard today are arguments that are going to be made, addressed, and determined by the Chief Justice. So he says, subject to any further arguments to be advanced at the application to set aside of 30th December 2019 or the application for summary judgment, which has now been fixed for the 19th of January, it certainly seems arguable that the plaintiff's claim on account of unpaid fees is in the nature of an equitable charge over the sums which have been transferred. So the Chief Justice has not predetermined anything. In fact,
can I ask you this point? Do you accept that Mr. Hill on the set-aside application is perfectly free to argue with respect to the learned Chief Justice's ruling in May, is perfectly free to argue without restraint that no solicitor's lien arises in the circumstances of this case?
Absolutely. Without any question, he can make all of the arguments that he has made before you to the Chief Justice on the 19th of January, and the Chief Justice will make his determination one way or the other. May I finish?
Yes, please do. I apologize.
Both in relation to his application to set aside the original injunction on the grounds, as he submits, that there was no cause of action pleaded, that there was no proprietary or solicitor's lien, and I will make my application for summary judgment, which of course will basically be the opposing argument. So to answer your question, there's no question at all about the fact that Mr. Hill can make those very same arguments that he is making today before you to the Chief Justice, who has indicated that he will hear everything and determine everything on the 19th of January.
And the curious thing, I suppose, is that if we were to grant permission to, well, A, an extension of time, and B, permission to appeal, it may be the case that it would be necessary to wait for the appeal to be determined before deciding the matters that are due to be determined on the 19th of January.
And my Lord, may I just say that one of Mr. Hill's complaints here is the delay which is taking place.
Yes.
So you're absolutely right? That may well be the consequence. The Chief Justice, when he hears that the application for an extension of time and leave to appeal has been granted, may well take the position that he should await the outcome of this application before the Court of Appeal before he takes the matter further. And the other thing is that your Lordship should not express an opinion on any of the matters that are in contest between the parties when those very same matters are going to be determined by the Chief Justice and may well be subject. Well, they may well be in the. They may.
I think it's something that important that I have to add to this.
Well, Mr. Hill, Mr. Hill, you will have a right of reply. Please don't.
Very well, thank you.
And the only point I'm making is that there may well be an appeal in relation to whatever the judgment of the Chief Justice ends up being following the January hearing. Of course, your Lordships are free to express whatever view and opinion you see fit, but it seems to me that the appropriate place for all of these arguments as to cause of action, as to proprietary claim, should be fully heard and argued before the Chief Justice. That's the point that I would like to emphasize.
Before you, I was going to say before you sit down, before you stop speaking, could you just help me on this?
Yes.
The Chief Justice has come to the view that it is arguable, though no more, that there is some form of proprietary entitlement to the monies that came from the trustee. There are 2 points that arise from that. The first is that I have some difficulty in seeing how that arises if, in fact, a request was made for the trustees to give the money to the firm. They said no, and then, but only then, a request was made for the money to be given to Mr. Crisson.
Well, I
I
think
mean,
there's
in
some,
those circumstances, had he A, not fulfilled what he agreed to do, B, was entitled to ask for the money to be given to him, and C, they were entitled to do so.
my lord, there was some issue of fact there, because my recollection of the evidence that was filed was that Mr. Crisson himself said to the trustees, do not pay the money to MDM, but pay it to me instead. So there is an issue of fact there that will need to be decided. I do not accept that the request was made, first of all, to the trustees, and they refused and then paid it over to Mr. Crisson. My recollection is that, in fact, Mr. Crisson accepts in his evidence that instead of asking the trustees to pay the money to MDM, he asked the trustees to pay it over to him. So there is an issue of fact.
Right.
That's a completely separate point, isn't it? I mean, that's a totally different point as to whether he's in breach of his contractual obligations under the acknowledgement of debt. But what I'm interested to understand is in paragraph 24 of the Chief Justice's ruling, he says that the new writ now expressly pleads a solicitor's lien being funds recovered in the ancillary relief proceedings. Can you explain why, and this may betray my lack of knowledge of the facts, but why are the funds paid by the trustees out of the trust funds, quotes, funds recovered in the ancillary relief proceedings?
Well, there were funds recovered in the ancillary relief because there was an issue in relation to the matrimonial home, which was sold, and there was an issue as to how the proceeds of those funds should be apportioned. The claim presumably made by the wife in the ancillary relief was to all of it, and the funds that were recovered by MDM for the benefit of Mr. Crisson was the $400,000.
And the matrimonial home was held in the name of the trustees, was it?
Yes, apparently so.
Well, apparently, or?
No, yes, sir. Yes, I have no reason to dispute that.
So the matrimonial home, which was the property you mentioned, was held on trust by the trustees on what trusts?
For the benefit, I understand, as Mr. Hill has explained, of Mr. Crisson and his daughter.
I think he said originally, Mr. Crisson, his wife and his daughter.
I think it might be a good idea. I don't have my client here. I think it would be a good idea if I get a definitive answer on who the beneficiaries were of that trust at the beginning and at the time of the making of the order and so on. I don't have instructions. I was not instructed in relation to the matrimonial proceedings, and I would hate for what I said to turn out to be wrong. And I don't have my client here. I'm unable to reach him by phone, obviously, using this system. I would prefer to be able to verify exactly who is said to be the beneficiary. But it's in something.
So we can send you the trustee, I imagine.
But there is correspondence from the trustee as to why they can't do it.
Well, the trust deed is a start. That will tell us the potential beneficiaries. But if there's further information. as to anything relevant to who the beneficiary at the material time was. We need that too.
Right. I will try and arrange for that to be sent to Mr. Quinn.
But we may be talking about the trust fund as being property preserved in the proceedings rather than property recovered in the proceedings. It seems to me to make no difference, but that's maybe what it is.
Perhaps, but that will be determined presumably on the strength of Mr. Hill's argument before the Chief Justice, and he will determine whether or not the relevant authorities do apply in the circumstances.
Right. The second question that I had is this: the injunction that was granted is effectively an injunction in Moreva form, because it does not refer to the monies in the Hong Kong and Shanghai bank account. It refers to any monies in any bank account. The Chief Justice referred to that in his judgment and said that that would have to be changed. But it hasn't been, has it?
In fact, I did send up an order to the Chief Justice, because he said, this is paragraph 34, he says, the fact that the draft order attached to the ex parte summons was not precisely in the same terms as the provisions referred to in paragraph 4 of Mrs. Marshall's first affidavit would appear to be a slip and should be remedied. And in fact, I did remedy it by sending up an order for him to sign. I can't remember whether we have it back. That's the only thing. To make it clear that it was a preservation order rather than a Moreva injunction.
But a preservation order in relation to a specific account?
Yes, and the specific account being the account into which the money was transferred, that being Mr. Crisson's account.
Well, I think we'd like to see a copy of that.
Okay.
Right. Thank you.
Thank you.
Mr. Hill, anything by way of reply?
Slightly, and we're going to end up in another one of these, the documents being before your lordships and your ladyship. We have received an email from the court in which the learned Chief Justice advises us explicitly that the only question which he determined explicitly, and I take that I'm therefore stuck with that as a finding that will be maintained in the further proceedings, that the injunction that was, the application that was made was a proprietary application based on the solicitor's lead. That is a finding that has been made by the court. It is extremely unlikely that Mr. Hargan, when he hears this matter, will go behind it, and the whole thing will be determined on the basis of this solicitor's lead, which is said to arguably exist. I say it does not arguably exist, that is something capable of appeal. It is a very, very quick point, and I agree with her ladyship that it's a matter that can be dealt with by this court, even in this session. If we have this afternoon, I could run around like a crazy man and get just the passages of Chitty tell you what the effect of entering into a compromise agreement is and what it does to the previous agreement. And then when you confirm, as they have done by insisting on the guarantee and affirm the contract in which the breach arises, then the contract lives, and it lives forever. You don't get to go back on that. These are not difficult concepts that are beyond us to argue in a couple of hours. And I will repeat, and I've repeated it quite a lot. This is an injunction that froze all of my client's assets on the 13th of December. We are now nearly a year along during COVID, when he's had no work, when his shop has been shut, when he wasn't entitled to any unemployment assistance in Bermuda. Throughout that period, he has had no access to his own assets. That is a travesty. And I'm here before this court, and if this court finds that the learned Chief Justice was wrong to find that there was a lien or arguable lien, and wrong to find indeed even that there was a breach of the agreement, then we don't need the hearing. And that is why I have insisted and kept on going And I will keep on going because Mr. Crisson deserves justice in some form. And if this court can help him, they should. And I believe that I've given this court enough grounds to suggest that I have a good reason for being late. That reason is substantial. That is the functus officio argument that I've just made. And that there is an arguable case that the learned Chief Justice allowed himself to fall into error. And the error that I raised before this court will be the simple one that the acknowledgement of debt is a note. It does not create equitable interests. There was no breach of that note. And in actual fact, if you follow what that note says, everything gets paid in accordance with its terms. That is the only point that I wish to make to your lordships in this session. And if we don't do it in this session, your lordships are quite right. We may end up having to wait until well into 2021. And I'm inviting your lordships to say that we'll do it the day after tomorrow.
What has happened? Mr. Puckey has said that he sent an email to the Chief Justice inviting a variation of the order. What has happened to that?
I haven't seen it.
Sorry, no, this was simply to remedy what the Chief Justice mentioned in paragraph 22. There's no variation of it. No, there's no variation of his order.
That is not a proprietary order, it's a memorandum of injunction.
So I'm getting hopelessly confused. What have you invited the Chief Justice to do?
To simply refer to the fact that this was a preservation order that was made on the 13th of December 2019, rather than a Morava injunction.
That's not the point. The point that the Chief Justice made in his order, in his judgment, was that upon the footing that it was a proprietary remedy, it was a proprietary remedy as to the £400,000 that had been paid into the Hong Kong and Shanghai bank account. In those circumstances, the only injunctive relief that could properly be obtained is to restrain the disposal of the monies in that bank account. What in fact the order provides is to restrain Mr. Crisson from disposing of any monies in any bank account.
And I might add to your lordship's suggestion there. If we go to the transcript of what occurred before the learned puny judge, there was never a suggestion that it was a proprietary injunction.
Yeah, you said that several times.
Yes, and the reason, but I was going to take one step further and say the actual finding of the puny judge was that the reason the order is granted is because if it's not granted, they will suffer a prejudice.
Yes.
My lord, just to answer your question, my assumption is that the injunction restrained Mr. Crisson from disposing of the funds into which which were paid into his bank account.
But that's not what it says.
Where are you looking at?
Well, the terms of the order is that the defendant must not in any way dispose of, deal with, or diminish any funds held in any bank account in the defendant's name, whether held solely or jointly, save for funds in excess of the amount of $242,457.99. That's what the injunction still in effect is.
I don't have the explanation for that. Perhaps Mrs. Marshall didn't know where the money went into.
What we do now, and as I say, I'll have to find it in the judgment, but the Chief Justice said that has got to be changed. I'll find it just a moment. And nobody has done anything. Sorry, it's taking some time to come up on the screen. Yeah, moment.
That's paragraph 22.
Right. Thank you.
Draft order.
And he sets it out. It says, it seems reasonable, considering the ex parte, paragraph 22, considering the ex parte summons, the affidavit of Mrs. Marshall of December 2019, and the order of the 13th of December as one set of documents, it seems reasonably clear that the application for injunction was indeed made under Order 29, and its purpose was to preserve the funds which had been transferred into the defendant's account, allegedly in breach of the agreement. The fact that the draft order attached to the ex parte summons was not precisely in the same terms as the provision referred to in paragraph 4 of Mrs. Marshall's first affidavit would appear to be a slip and should be remedied in due course. Now, what in fact has happened is that nothing has happened in due or any course, and the applicant has been restrained from disposing of any funds in any bank account, as opposed to disposing from funds in one specific bank account. Well, I suppose we could, at least by way of appeal, change that.
Not sure that helps, my lord. The vast majority of his funds are in that account.
Right. Well, trying to be of some assistance.
But to take up your point, what I say is an application wasn't made for a proprietary injunction, and the order that was actually made reflects what was asked for, because no proprietary injunction was ever asked for.
I do follow that, Mr. Hill. You have actually said that, I think, about 5 times.
Well, I've overdone it, and my pupil master once told me that if a point's worth making, it's worth making 4 times. But
your pupil master was wrong on that.
I'll have a word with him.
Yes, and I'll find out in due course who he was.
Charles Pride.
Oh, yes. Oh, well, very distinguished. Now, joking apart, can we have a look at what is on the cloud as MDM, and in particular your email of Tuesday, the 26th of May? Have you got that?
Who's the "your" in that case, my lord? Sorry.
It's you.
Oh, okay.
That's what I mean by.
Yes, my lord.
You say there, sending an email to Mr. Pashai and to the court. To be clear, neither my firm nor I have ever been directed to do or abstain from doing anything, and I remain the attorney of record. Yes. And then you say, I've told Mr. Machai that I will do nothing. How do you square the first sentence with your contention there was a direction from the Chief Justice which had the effect that you couldn't file a notice of appeal or leave to appeal?
All I can say about that is that goes too far. What I meant is I can do anything in relation to the variation application, because the Chief Justice is, and if you look at before the document before that, I tell Mr. Pashai exactly what.
Sorry, you've faded from the microphone. Right?
If you look at the page 13, no, hang on, page 21 of the exhibit that your lordship is looking at.
Well, mine hasn't got any page numbers.
Well, it's the document. It's about 2 pages before that.
Right.
2 pages before that.
Yes.
I state, I'm going to get the book.
So which email is this?
It's an email from me to Mr. Pashai, I believe.
Yes, of what date?
It's quite long, as I'm prone to a bit of prolixity.
You are. What date?
It is dated the 12th of May. Quite long,
well,
and I need to get towards.
The first email that I have is the 13th of May.
I'm looking at it. It's in my exhibit to my second affidavit at what looks like page 19 to me on the 12th of May. I think Mr. Pashai might respond to it on the 13th.
Well,
in that chain of emails on the 13th of May that starts with Cameron Hill, if your lordship goes to page 6 of that chain,
I'm sorry, the problem is that what we have on the screen doesn't have a page 6. It starts.
The one that starts on the 13th of May, as you
Yes,
go down, you go backwards in time.
I know that.
And eventually you come to a fairly long email from me.
Well, sorry, I
6 pages in.
no, I'm afraid you don't. Not in the one that we have on the screen.
Very well. May I read to your lordship what I
Yes.
say towards the end of that? The first email is on the 12th, and I say, my undertaking would be along the lines of not to do anything, discuss with the client or his counsel, if any aspect of this case until further order or your client's consent. However, I do require one thing from the court, which I have been waiting for ages. I have asked for a copy of the audio, as well as a copy of the judge's notes of the hearing of the 13th of December, 2019. So that is me giving an undertaking to do nothing. And the correspondence which your lordship is looking at, that we've been looked at this morning, is me continuing to seek the audio, which I started seeking before the variation application. And the undertaking I give to my learned friend, which I believe I'm bound by as a matter of principle and honor, is to do nothing save with another order or consent. My undertaking would be along the lines of not to do anything, discuss with the client or his counsel, if any aspect of this case until further order or your client's consent. However,
Well,
I do require those audios. And that was the only thing I was looking for.
Yes, well, I think we would like to see that email, but that's the undertaking that you were prepared to give, but never in fact gave, is it not?
Well, I didn't give it. I believe that's an undertaking. It doesn't need to be in writing. It's a promise I made to a professional. And if I didn't stand by it, I'd be hauled in front of the complaints committee in a minute.
Right. Well, we'd like to see that correspondence, please.
I will have a word as best I can with Mr. Coelho this afternoon. I know he's very busy as he gets to the end of the session.
Right.
But that was what I promised to do, and I repeated it a few times that I wasn't going to do anything. Because the last thing I wanted was an ex-parte order in which I got lumbered with a pile of costs.
Right.
Mr. Hill, could you give me the page number because I think it's in the exhibit to your second affidavit.
It is indeed. The page number at which it appears is page
21.
Page 21.
21, the third paragraph from the end. And that's on the 13th of May. So that's a week after the ruling. The ruling was in fact delivered on the 8th of May. I found out nothing turns on it. And that was what I was saying to my learned friend, because I had received the letter from Marshal Diel and Myers telling me that they were going to go and get an ex parte order against me, preventing me doing anything. And I was undertaking this bulk hire application at my own risk, because of course, Mr. Crisson has no access to his funds. And I said that to the judge, in fact, during the bulk hire application. So it's simply not correct to say that I magicked all this up in the 26th of May. And on that date, I told him what I wasn't going to do, except try and get the audios. And the email to which we've been referred this morning by my learned friend is about getting the audios from the court. So one thing I tell him I'm going to do, and he still objects, by the way. And that's what elicits that rather annoyed response from me, which goes slightly too far.
Right. Okay. Thank you very much.
And then the next point about what is the status of this injunction. If my application to set aside is successful, then we can all go home and enjoy a nice bottle of wine. If my application is unsuccessful, the difference between a moravian injunction for my client and a proprietary injunction is vast. Because if it's a proprietary injunction, he doesn't get his hands on his money for his ordinary course of business debts. If it is a moravian injunction, he gets his hands on his money to meet his debts. It will not surprise anybody to learn that Mr. Crisson has other creditors who are champing at the bit, if I can put it that way, to get some of the money that is being released to him from the trust. They have an interest. They haven't wished to participate. I have been dealing with them, although not perhaps, I must stress, while the Bokai application was going on, I didn't speak to any of his bankers. I took no steps at all. And they are interested in the outcome, and the existence of a proprietary injunction is decided. As far as the Chief Justice is concerned, he can't go back on his order. He's not allowed to, the law doesn't permit him to. I'm stuck with a proprietary order which changes the game for Mr. Crisson enormously. And if I'm now being told that to make that point good, I'm going to have to delay the set-aside application perhaps until sometime in the summer next year, then I'm left with it in a very deep quandary. But my hope was that we could get this done this session, this point. It's not a complicated point. I've explained it to my learned friend a number of times. I provided a bundle of authorities running to 22 or 23. I don't think we'll need that many. If you just read Chitty, you understand what I'm saying. And I really hope that if your lordships are minded to grant an extension of time, and I encourage your lordships to do that, and I hope your ladyship doesn't mind if I stick to your lordship, I'm French, and if there's one blow, they all get to become blows. If we cannot help Mr. Crisson now and do him some justice, they've been waiting a year. If we cannot help him now, and we can, and we refuse to, then, well, I'm not going to go any further than that. I think your lordships have my point. And if we hear the question of whether or not the lien existed, at least that gets him that far. And if the lien doesn't exist, then there was no breach. And your lordships can deal with all of that in 2 hours.
Can we just see where we are in monetary terms? The money that was paid into the Hong Kong and Shanghai bank account was $400,000.
Yes.
Of which he paid $100,000 to MDM.
Yes.
That would leave $300,000.
He paid a credit card off to the tune of $50,000 as well.
So that gets us to
$200,000, and then the bank nabbed some, and I think the sum held now is $230,000.
So there's $230,000 in the account, roughly.
Yes.
And he owes MDM $280,000.
Well, he owes MDM, if you follow the agreement, nothing. But the order was made for 240 odd, because he's paid 100 grand and he's paid some of the installments and the guarantee. In fact, there is no money that will be left over at the end. So I say there's no actual damage by what happened. I mean, I say there was no breach. Even if there was a breach, there was no damage. The sum that is injuncted includes for extra fees and past fees. Other monies have been added to it. And the sum that was injuncted was $242,000,
Right.
which exhausts the balance of the HSBC account, which is the only account that Mr. Crisson has and has any money in it. Because of COVID, his shop shut. And as an owner director, I don't believe he was entitled to any unemployment benefit, and he has exhausted all of his savings.
But how much on any view does he owe MDM?
How much on any view does he own? Under the I don't know, but my calculation is that under the acknowledgement of debt, he owes about 150.
Right.
It might be slightly more, it might be slightly less, but it's in that neck of the woods.
Right. And he has other creditors as well.
And then if it's a Moravian injunction, he can use his money to meet his ordinary course of business expenses, which would include the interest that he owes, because he's not paying interest on any of his loans.
Yeah.
His overdraft has gone up and up and up because he can't pay that. His life has been made worse. And there was no reason for this delay. This is a simple case of debt. It should have been done for $20,000. And here we are sitting in the Court of Appeal 1 year later. And with all due respect to the system, that is an enormous denial to Mr. Crisson. And if there is a mechanism for us today to answer some of his questions, I submit to your lordships that we should seize it. Right. And I believe that I have offered your lordships enough to seize it. And we have just the right number of days to be able to hear a 2-hour case on what was the effect of entering into the acknowledgement of debt that extinguished all of the rights and obligations of the parties, because that's a natural consequence of a compromise. There was consideration for it in the mutual releases that it contains. There was consideration for it in the ongoing acknowledgement of debt. And it is the only document that was relied upon before the judge, the puisne judge, on the injunction. And those
Mr.
questions.
Hill, can I just interrupt, please? Were you saying a moment ago that you could make your submissions in an hour on this issue?
If you tell me to make them in an hour, that is exactly what I will do. It is
Right.
not a complicated point. There is case after case after case after case that tells you once you've made an election, and I say they have made an election because they've demanded payment from the guarantors, after the issuance of the writ and before, once you've made an election, you make it forever unless you find another breach. That they didn't accept the alleged breach in any event because they say there's a repudiatory breach occurred. He's been a bit of a naughty boy and now I've got an equitable claim. So there's a repudiatory breach, which isn't accepted. So where are we with that? They may have a claim to damages, but as I've just described, if you allow the contract that they entered into, which they themselves rely on, you get everything paid off in accordance with its terms. This has been monumental. I've been at a loss to understand how we have allowed this to go on for a year, to deprive a man of his assets on the basis of what I've just described. And what I've just described is unarguably correct. What I'm saying is so obvious, I submit, that I can do it in an hour. And anyone who has done any shipping claim knows that the last thing you ever do is rely on your charge of party once you've terminated it.
Yes.
It's not complex. And they have relied on this agreement after they purported to not terminate it, as it happens. And I think we can do it in a couple of hours with a bit of goodwill.
Yes, I think, I mean, you fulfilled what your fuel master said now quite well.
I shall write him and give him your lordship's comments. We're still in touch.
Okay. Well, we're grateful to both parties for their submissions, and we will now have to decide what to do. Unless
I also had
anything
Alistair
else.
Schaff, but he didn't make that point.
Unless there's anything else, we will retire for that purpose. And
Are we going to the
Thank you.
breakout room?
yes, we are.
Do we sit and wait, or do we?
Yes.
What's
Sit and wait. Leave your cameras and mics turned off.
okay?
The prompt will let you know to come back on. So the
Okay,
judges.
thank you. I'm grateful. I stop video. It's mute, right? That's what I hit.
Hello?
I'm here.
Okay, I don't see Mr. Pichai.
Mr. Pichai doesn't seem to be with us at the moment.
Can you hear me? No. Just, why are they not seeing me? Start the video.
Mr. Pichai, you can be seen, you can be heard, but not seen.
Okay, we don't know how to get it back.
There's a little button down on the left corner. If you hit that, it's got video. There's little things look like cameras and microphones. I think they're the trouble makers for us all.
Start the video.
We really need one of our children somewhere nearby.
It says you cannot start your video because the host has stopped it.
That's all your fault, apparently, Mr. Coelho.
Yes.
Usually the case.
No.
I've now asked you to start your video. There you go.
Here we go.
Ah, very good. Thank you very much. We're all here now, I think. Yes, we are. Well, as you can see, we've been considering what to do in relation to this matter, and we have it in mind to give permission to appeal and an extension of time upon the basis that we will have a hearing this Friday, extending for not more than 2 hours. If there are further written submissions, we will entertain them, but they must come in by Thursday evening our time, and they should not exceed 10 pages.
I was going to ask for 15, but they'll take 10.
No, 10. Don't say there's anything more than once. And we also will need, and the parties should liaise with each other and Mr. Coelho to have A, the documents that we've already indicated that we would like to see, and B, any others which the parties seek to rely on. We cannot have a situation whereby we find at 3/4 of an hour after we have begun on Friday that the vital document has not been provided and cannot easily be obtained. Now, does that suit?
It does. It raises one administrative issue, that my grounds of appeal are much wider ranging than that, much wider ranging than that which I was discussing previously with her ladyship, and perhaps discussions might be limited to whether or not there was a breach, and whether or not what is the effect of the acknowledgement of debt and its terms upon the retainer and the rights and obligations of the retainer, which do indeed give rise sometimes to a lien. And it was on that point that her ladyship, I think, as I understood it, began to entertain the idea of doing it fairly quickly and in good faith. It might be better if we limit my submissions to why I say there is in fact no cause of action and no breach.
Well, Mr. Hill, it's got to be an appeal once and for all. You're not going to have a second bite at the cherry. So you can't reserve anything back. So anything that's not in your grounds of appeal in relation to the judgment is not going to be on the table. And speaking for myself, we can see what you've said. Nothing new should go outside what you've said already. And speaking for myself, I think we should dispose of all the points you raise, not simply limited to the point which you were dealing with, which is the substantive issue of law.
Very well. I was trying to limit things just to get it done, but I hear your ladyship, and then
Yeah,
I shall
no,
conduct myself accordingly.
we can't leave open a door to have another go.
Well, I was thinking of abandoning them. I was going to do better than that, but I'll
Well,
take
if
your
you feel like
ladyship's point.
abandoning them, let
Well,
us
no,
know.
I don't. I was now that I don't have to, I don't think I'll bother. But I will keep my submissions to 10 pages, and I will say what I have to say about the existence of. It is my main substantive point of law, and it's the one that I've been wanting to bring to the court's attention for a very long time indeed. And I'm grateful to this court for giving me an opportunity to do so.
Right. Mr. Petrie, is that okay? All okay with you?
My lord, you've made your decision, so we will have to obviously abide by it. Are we fixed for a time on Friday, or is that still open?
Well, there are some directions to be given in a number of cases, I think about 3, but they are directions as to when various documents should be produced. I don't think there's anything of great substance. So I think you ought to be ready to start half an hour after we start.
This will be on Friday morning.
On Friday morning.
And we'll be finished by lunchtime.
Yes.
I'm grateful. Who draws that order?
Well, do we need to draw an order up at the moment?
Well, no, it's not essential. We've all heard what your lordship has had to say, so it's not essential, but sometimes people are sticklers about this sort of thing.
Well, in circumstances, subject to anything Mr. Coelho has to say, in circumstances where we're granting leave and we're going to have the hearing on Friday, we'll have to draw up an order in relation to that. I think it would be convenient to have an order which says both.
Well, the reason I'd like an order is because I need it to be next to the refusal of my application by the single justice, which could be read in a particular way as to imply that I don't quite have a clue what I'm doing. And so I'd like the one that overturns it to be very quickly put on the website so that people do not gain that impression.
Well, I'm not sure how people are going to be gaining such an impression.
By setting aside the ruling of Bell JA.
Oh, I see.
Well, I'm not sure we are setting it aside, where simply you had a right of renewal to the full court, and the full court has decided that you will have permission to appeal.
I think we can draw up the orders together, both in relation to the application to appeal and in relation to the appeal itself.
I'm grateful.
Right. Well, we shall meet again on Friday. But please, as I say, do liaise with each other and with Mr. Coelho about the production of all relevant documents and any further limited skeletons within the time that I've specified. Thank you very much.
Thank you, Robert.
Thank you. All these proceedings are adjourned. Have a good day.
We'll go back to our breakfast room.
We should perhaps liaise by email, Mr. Coelho, or do you wish to speak to us by the telephone?
I'll speak to you by Zoom later this afternoon.
I'm grateful. Thank you.